Yeah, welcome back. Meeting to 116 of the Standing Committee on Industry, Science and Tech. We are continuing our review of the Copyright Act, and today with us we have from the Council of Ministers of Education Canada, the Honourable Zach Churchill, Minister, Nova Scotia Department of Education and Early Childhood Development, as well as Wanda Noel, External Legal Counsel Copyright Consortium. So we're going to get right into it, sir. You have up to 7 minutes, and then we'll proceed with our questions. You have the floor.
Thank you very much, Mr. Chair. Bonjour tout le monde. Committee members, thank you so much for your time today. I do want to recognize Wanda Noel, who has been the counsel for CMAQ on the copyright issue for quite some time. I'd like to recognize Andrea John and Chris George in the audience, who are here in a supportive capacity. And selfishly, I'd like to inform the committee that my wife and daughter are also in attendance, Katie and Cecilia Churchill.
Hello.
So that's who the baby is. Very much appreciate the committee's time on what is a very important issue in this country, and has had substantial conversation since the 90s around copyright. And I think it's important to recognize that there's two key public policy objectives that we're trying to accomplish. One, to ensure that the rights of authors, of creators, are protected and that they're fairly compensated for their work, and that industry can flourish in this country, but also to ensure that our public education system is able to access the widest range of materials as possible to ensure the long-term success and well-being of our students. And so fundamental to this conversation are two key aspects around copyright. One is fair dealing and our understanding of fair dealing. And that's a difficult question to understand what's fair in terms of trying to juggle these two public policy priorities. And luckily, I think for all of us in the room, the courts have done a lot of work in that regard for us and have worked very hard over the course of 10 to 15 years to establish an understanding of fair dealing in the country, which we believe, as Ministers of Education, our policies fit well within. The second question is around the idea of a mandatory tariff to be imposed on the education system. So this is something that we do oppose. We support the court's definition of fair dealing, and we do oppose a mandatory tariff on education materials. And I think it's important to recognize why that is. We believe that with scarce public resources that we do have in this country, in our provincial jurisdictions, that we ensure that every single dollar that we spend is in the classroom and geared towards student success and achievement and well-being. And of course, a mandatory tariff would take tens of millions of dollars out of our education system, out of the classrooms of potential future writers, creators in this country. And I think it's important to note that this is not an education sector versus a creative industry issue, although there is some disagreement. We have a vested interest in the success of a vibrant, robust, healthy, successful, innovative, creative sector in this country. In fact, our education system is dependent on that. And we recognize that there has been some changes to the economic model of these sectors, the result of technology, internet, open source information. Information that's being used in our education systems. But we don't believe a mandatory tariff is the best way to provide support to that industry, because we do believe that takes money out of our classrooms, where our precious dollars are very much needed. I do want to discuss two issues that I know have come up in conversations at this committee. One around the amount of full textbooks that are being copied. I know that's a concern for the industry. That would be a concern for us as well. That would fall outside of the guiding principles of fair dealing and use of copyrighted materials in the country. And thankfully, we've had the Federal Court of Appeal and the Copyright Board look at this question on two separate occasions, and they've discovered that 98% of copying that does happen in our education system is actually within the context and following the principles of fair dealing. I think that's something that we should take great pride in. 98% is a passing grade. And so I don't think we should look at bringing in a mandatory tariff in response to what is a 2% anomaly in our education system. Also, I know it's been argued that the revenues from the education sector to the publishers and to writers has been impacted by the change in fair dealing and copyright legislation. But I think if you look at the Statistics Canada information that we've provided, you'll see these in your packages. You'll actually see that since 2012, sales have actually gone up for the P to K, or sort of the K to 12 education sector for books in our country, and I think that's something that we should also take great pride in. That's happening at a time when, as I mentioned, technology is changing and the delivery of education in our system is changing. So in closing, I do want to state that as ministers of education in this country who are responsible to be stewards of our education system, who are responsible for delivering high quality education to our students, we do support the court's definition of fair dealing, and our guiding principles, I believe, are in line with that. We've provided those as well to you. And we are committed to working with yourselves, the federal government, and industry to come up with innovative, creative ways to support that industry, to make sure that it's successful and thriving so that we can all benefit from it. We just don't believe that subsidizing it for money from the classroom is the best way to accomplish that. And I will let the committee know that we're also, as ministers, investing $5 million nationally to further copyright education with our educators, to make sure they are very well aware of their roles and responsibilities, and also to do further assessments of compliance around copyright. So I thought that would be of interest for the committee as well. Thank you very much for those opening moments, Mr. Chair. I'm very happy to entertain any questions.
Thank you very much. We're going to jump right into questions. Mr. Bayless, you have 6 minutes.
Chair? 6, I better reset my clock then. Thank you, Mr. Churchill. You say that you're interested in supporting a vibrant Canadian creative industry. How? How would you do that? And I want to talk how about money, because ultimately people need to be paid. So I'd like to see how would you do that financially?
So I think there's various incentives that are in place across the country. There's tax incentives, there's grants for creative industries, there are competitions. So I think we need to look at best practices from one jurisdiction to the next. That's something that as ministers we can work with the federal government on to identify the best way to incentivize growth in that sector and ensure that it is in fact successful. What we don't think is necessarily forward-looking is to look at a mandatory tariff on the education systems across the province as being the best way to do that, because again, that does take tens of millions of dollars. That will take tens of millions of dollars out of our classrooms where those monies are desperately needed. And instead, I think we need to look at more general opportunities.
Is that tens of millions of dollars? Is that what you figure you've been saving since the fair dealings has come? That part of the act has come and applied to education.
Well,
you said it would take it out. So let's assume that's about the savings you've seen across the country, tens of millions.
I don't know if I would characterize it as savings. It's dollars that we have not been spending in tariffs that we have been directing into student assistance.
You're not spending it, but if the law hadn't changed, you would be spending it. So therefore, you're not paying the creators that tens of millions. Do you know how much that tens of millions is?
The tens of millions would be based on the 1331, I think, per textbook tariff that is currently being asked, I think, by Access Copyright. So that's in response to that particular ask. And obviously, as I mentioned, we don't believe that.
No, I believe Access Copyright says they've lost tens of millions since this come in, and we'll ask them when they come up after you. And you're saying that you would save tens of millions.
We've been able
or you are saving,
if we were to have a mandatory tariff forced on the education systems across the province, there would be tens of millions of dollars that come out of our education system.
Fair enough. And you did mention that you think that the creators should be fairly compensated for their work. We've had a number of creators come before us, actual people, and I'll be honest with you, I was shocked that when they started talking about their drop in income, they said 70, 80, 90%. Fair enough, those are statistics, but the overall amount really shocked me was they're talking, I used to get $2,000, now I'm getting $300. I didn't meet anybody that was particularly getting rich off of these tariffs. In fact, even my sister happens to be a publisher, and I asked her, she goes, yeah, I get a check from Access Copyright. I can't remember what it was. It was a few $100s. It's insignificant to her. She couldn't be bothered to look it up. What would be fair compensation for someone that writes a book, they say spend a year writing a book? What would be fair compensation
So,
for
so
that
that's a
person?
difficult question for me to answer as a minister
Give
of
me a
education.
ballpark.
Well, I mean, I'm not going to try to provide information that wouldn't be accurate and speak outside of my expertise. Member, I hope you can appreciate that. What I can point to is that we recognize there's a whole host of factors that are impacting publishing in particular. The textbook isn't the primary source or is becoming less of a primary source of information in our classrooms. The internet is changing the face of the publishing industry. Technology is forcing that industry to evolve, and it's creating challenges. We recognize that. But when you look at the actual revenues from the K or P-12 system, those revenues to the publishing sector has actually increased. And again, I'll reference the
Do you know how much,
Statistics Canada
I see
data.
that, how much of those are going to Canadian content providers as opposed to international? When you say they're growing?
Yeah, Wanda will help me answer that for you. But
If you look at the handout, you will see that Canadian publishers' sales of their own titles in K-12 educational institutions have gone up from in 2012 to 2016 in that graph. So
These are-
presumably Canadian publishers' own titles is Canadian content. So it's increasing.
Publishers' sales of their own titles, so you're saying that Canadian publishers last year went from 300,000 to 400,000, or 3 and a bit to a little under 4, is that your
It's
chart?
it's actually million.
300 million.
Yeah. And the graph, this is Statistics Canada data. They study the publishing industry nationally. And this was extracted from studies that was done of the publishing industry in Canada in 2012, 14, and
So,
16.
in 2012, though, you would have been contributing before the law, and 2016, you would not have been contributing. Is that fair to say?
that
No.
you go ahead.
No, I don't think that that's fair to say.
What did you change then when the law changed? When why are you trying to defend your fair dealings if it doesn't have an impact for you? I need to understand that. If it doesn't have a financial impact, why do you need to defend it? Why are so many people coming here to defend it and at the same time saying it has no financial impact? It either does. There's a reason that you want to defend it, and you just said it tens of millions. Can you make that link?
So a change of understanding in fair dealing, we believe, would have a financial impact. The way fair dealing is defined right now, that if you have a short excerpt of
I know what fair dealing
materials.
is,
Okay.
but you're defending it because you want to save money. Is that fair to say?
We're defending it because we believe it's fair. The courts have gone through extensive deliberations and decision-making to come up with this. It's quite complicated to develop what's fair from, an academic learning standpoint to ensure our students have access to the widest range of materials possible, and obviously ensuring that creators are properly compensated. So that's not an easy question to answer.
Fair enough, thank you.
And the courts have helped us do that.
Thank you. We're going to move to Mr. Lloyd. You have 6 minutes.
Thank you for being here at committee today. My first question will be in regards to previous testimony that was provided by your organization in 2011 when the committee was reviewing the Copyright Modernization Act. Your group appeared before committee and promised that the addition of education to fair dealing would have no negative impact on creative incomes, and that you would pay collective licenses and would continue to do so after the amendment, and that you were not trying to get material for free. Since 2012, you are claiming vast amounts of work for free, like there's been hundreds of millions of pages printed that's been documented. You have not been paying collective licenses, and creative incomes have been in serious decline. Do you still stand by the earlier testimony provided in 2011 that there would be no impact on creative incomes?
So we benefit today from having Wanda Noel, who was actually present during that, who can speak better to the comments of the minister of the time. But in terms of the hundreds of millions of dollars of copies that we've seen used, that number, I do think it's important to question where that number comes from. We have not seen evidence on our side that is an accurate figure. And in terms of what we do know based on Federal Court of Appeal assessment and Copyright Board assessment is that 98% of copying that happens in this country in the education system is within the parameters of fair dealing. So I think it's really important that we don't know where that number comes from, and I think it's important to have a better understanding
I
where
believe
that
it's
number
a
comes from.
Price Waterhouse Coopers number, and that's a internationally recognized auditing agency. So presumably, if that's the number that they're coming up with, there's some sort of evidence behind that. And your evidence that you brought today that there are savings of tens of millions of dollars is also backed up by Price Waterhouse Cooper information, which indicates that since 2012, authors and publishers have lost $30 million because of fair dealings, which seems to corroborate the evidence that you provided that this does cost tens of millions of dollars for universities to provide collective licensing. So I'm just wondering, you have talked about the precedents in cases, but in regards to the York decision that recently happened, which happened after the Supreme Court's ruling on fair use, do you still feel that you're on the right side of the law after the York decision?
Wanda, I'll let you speak as counsel.
There's a lot of questions there. Let's deal with Minister Genex's comments in the Copyright Modernization Act. Minister Genex's statement in 2011 or 12 was correct, and it's still correct, because adding education as a fair dealing purpose, which is what happened when the Copyright Modernization Act was passed, had nothing to do with the fair dealing guidelines. The fair dealing thresholds and guidelines are based on Supreme Court of Canada decisions that took place after the Copyright Modernization Act was passed. So that's one thing. I saw a headline recently that said something like Minister Genex lied to Parliament. Well, that's not correct at all. It's just wrong. Your reference to the PricewaterhouseCoopers report, the origins of that report was one report that was filed at the Copyright Board by Access Copyright, who's in the audience this afternoon, and another expert report that was done by Deloitte. So when you're in a Copyright Board proceeding, you have dueling experts. So that PricewaterhouseCoopers report takes one point of view. There is a corresponding study that says that everything that's in that report is incorrect. So it's dueling economic experts, and I would be more than happy, on behalf of Minister Churchill, to provide a copy of the other expert report that says PricewaterhouseCoopers is wrong.
Is that a Deloitte report that you're referencing?
I think it was Deloitte, or I can't remember. I think it was Deloitte's, yes. I mean, it was several years ago now, but I can provide
Please
the report.
clarify after. Thank you.
And the other thing, the York case under appeal, sorry, I'm not going to take up time here. That is under appeal, and we have multiple cases interpreting fair dealing consistent with what Minister Churchill said, and we have one case that has a different interpretation. So we'll let the courts do their work, and they can figure it out, because it's based on evidence and a very complicated process that can't take place in a parliamentary committee.
One more minute. Okay. My next comment would be, this is very interesting stuff that has been provided here. How much would you say that you spend on Canadian content? Because one thing that we've seen throughout our testimony is that university and K-12 spending is up. But we've seen that coming from international publishers, international authors in terms of the scientific and engineering fields. So can you provide some specific information on how much Canadian content creators have they been benefiting? Has there been increased spending on Canadian content creators since 2012?
The numbers that we do have available, member, are provided to you in your package. And I don't know that we can extrapolate Canadian content specifically from those numbers.
Thank you.
Thank you very much. And if you can forward to the clerk that report that you are referencing, that would be very helpful. Thank you very much. We're going to go to Mr. Massey. You have 6 minutes, sir.
Thank you, Mr. Chair, and thank you, Mr. Minister, for being here today. So essentially, the bottom line here is, I want to make sure it gets clear, it's just for your province, it's $10 million. Is that correct in terms of the cost if there was a change?
If the proposed tariff at $13.31 was imposed, nationally that would be over $50 million.
Okay, nationally, okay, so, and does it include the territories as well too? So that's
That does include the territories. That doesn't include Quebec. So
Right,
this is,
okay.
that is one thing I forgot to mention, is that I'm here representing the education ministers outside of Quebec, but that does include the territories.
Okay, that's why I just wanted to make sure on that. Now, if the old system is in place, has there been any work done in terms of what the difference, the cost differentiation would have been for today? Like, I mean, that's new money that you're being asked to, if that is brought forth in terms of the fee. But do you have any idea of what the cost would have been had Access Copyright not proposed that, and just the status quo before even fair dealing was brought in place? Like, what would your cost be today if the old system was in place? Has that been kind of looked at? Yeah.
The rates of the tariffs
Yeah.
are set by the Copyright Board, and they're almost constantly appealed.
Yeah.
Prior to the tariff system, the fee was around $2.50 per full-time student equivalent.
Yeah.
The Copyright Board set a tariff that was $5 and pennies. Ended up at $4.81 when the appeals were exhausted. So there's 4 million students, so 4 million times
Yeah.
$5, you can do the math.
Yeah.
That was the case that the Ministers of Education took to the Supreme Court of Canada, and the decision was that short excerpts could be copied by teachers without paying copyright royalties. And then in 2013, based on that decision, the Ministers of Education stopped paying the tariff and decided to rely on fair dealing and licenses and databases and repositories and other things to meet their copying needs. So that's the range.
Would it be fair to say then that there has been a cost savings in that process, then there's been less expenditures because of that?
I would say no, because the money that's spent, as you'll see, is
Yeah.
increasing. It's
Okay,
just not
yeah.
being spent on the
On
same
the same
things.
thing. So this is what
It's
we're
being
running
spent
into.
on something different.
So just in general, though, what we're hearing from not only just witnesses, and I know you have Stats Canada stuff in front of us, and when we have witnesses and people coming forward, it's not always representative of the full picture, there's no doubt, but it would seem to me that there's fair enough, we're running into a pattern of experiences where there seems to be some winners and losers with regards to the transition. And when government policy changes something, then I think there's probably some expectation that there should be some amelioration or some public policy to help done that. Do you believe that there has been, I guess from your experiences in terms of the works that you've been purchasing or your interaction, any changes with your own, maybe in your own province with regards to some of the content providers? Has there been any look at that as to whether there's been a shift since this has taken place? Some authors say they've given up, they're not producing anymore, they reduced their amounts. Has there been any examination to find out whether in Nova Scotia, whether you have has it transitioned to new content providers, or is it just been the same?
There's been a move. There's been a move in our jurisdiction to more local content. So we've partnered with our African Nova Scotian community. We've partnered with our Indigenous population through our the Mi'kmaq Nation. We've partnered with local writers to ensure that there's more local content in our curriculum. So there has been a move in that regard in Nova Scotia. I can speak to very specifically, and I do think that has happened in other jurisdictions as well. The fundamental question here is, how do we define what's fair between what the needs are of the industry, which we recognize, and what the needs are of the education system. And so around the idea of fair dealing, I think that we have, the courts have done a lot of that work for us. They have heard extensive testimony from both sides of that equation and have come up with a definition that we believe makes sense and that we don't want to see, thrown out overnight.
No, I understand. I guess I'm looking for the response. Every time I hear that the courts are dealing with that process, that's a failure of public policy from our point of view, federally in this particular instance, because what we do is we make decisions here that need sorting out in another jurisdiction because they still haven't fully, and maybe perhaps with copyright, the complexity of it and the changing way things are done, it was bound to end up there in some way or fashion anyway. But I guess what I'm looking for is the things that were done or what could be done to help some of the artists that are still transitioning here. And that's what I'm curious, in terms of your representation of the provinces. So was there any overall, I guess, plan, or is it basically each province, and you mentioned like Nova Scotia, what you've done, some of those things are actually, I represent an area of the Underground Railroad, so to Canada. So I know some of the stories quite directly that relink my community to yours and so forth. But do you know if the other provinces were doing or are doing more comprehensive work to try to bring forth local culture, maybe new artists and new content providers?
I mean, it does vary from province to province, and it's primarily in the field of the, heritage departments, the culture departments that exist provincially. But as a representative of the education system, I do think we're doing our part to make sure we have more local content, particularly around parts of our history that haven't really been told from a local perspective.
Thanks.
Thank you, Mr. Chair.
Thank you. We're going to move to Mr. Sheehan. You have 5 minutes.
Thank you very much, Minister, and appreciate you being here as well as Wanda today to help us out with this copyright review. Recently, we did a cross-country tour, which allowed us to hear from various regions, various school districts, authors, and universities and colleges from coast to coast. And we are in Toronto. I heard a testimony about from someone, it was fairly good, and they likened it to the 401, which is their superhighway down there, that someone will drive, 100 when they first, get their license, but then they go up to 105, 110, so on. Next thing it's 120, and next thing it's the Autobahn. And she was likening that to the copyright, that someone takes one copy just cause, and then so on. And fast forward along, we heard testimony from some authors in Western Canada about their whole works being photocopied and distributed to classes. So my question to you is, what steps do school boards or the province take, the ministers of education, to educate teachers and students on the copyright laws? What kind of policies did they put in place would be my first question.
Thank you very much, and that's a real important question, because this is important to us as well. We want to be following the guidelines of fair dealing, which means short excerpts only can be photocopied. Mm-hmm. We have heard anecdotally that there's examples of educators photocopying a full text book, for example, and distributing that. The evidence, though, that's been assessed by the Federal Court of Appeal and the Copyright Board of Canada indicate that in 98% of cases, photocopying is happening within the confines of fair dealing. And I think, part of our success in that regard is the education that we're providing to our educators. We do have manuals that are distributed to every single educator or every single school in the country. We have these sorts of posters that are supposed to be at every single photocopier to inform people. We are further investing money as Ministers of Education, $5 million to enhance our education on copyright and what the roles and responsibilities are of the teachers, and to do further third-party assessments on how we're doing. So the Federal Court of Appeal, the Copyright Board of Canada have consistently said 98% of photocopying is happening within fair dealing. We're going to spend some money, utilize an independent third party to come in, provide us with an additional assessment to make sure that we're doing our part, because we do not want to be operating outside of the realm of fair dealing, and we do have a vested interest in the success of our creative industries. Our education system is dependent on them. We just need to make sure that short excerpts, information from a wide range of sources are accessible to our students and available and affordable. Okay, so the 2%. So you've indicated 98% are complying. The 2% that the stat came out with. Do local school boards, schools monitor, and how, if so, how? And then if they find a student or a teacher not in compliance, what steps are taken? So in terms of enforcement, that process will vary oftentimes from province to province, from school board to school board. But as with any rule that teachers are supposed to be following, that our administrators are supposed to be following, there's a process in place in each one of our jurisdictions to ensure that the rules are being followed. And whether it's if something happens, it's either dealt with through a performance mechanism or through disciplinary action, depending on what's appropriate. But those processes do vary from jurisdiction to jurisdiction, but they're there.
And I was a former school board trustee many years ago, and the funding models have changed in different jurisdictions where the mill rate isn't set in Ontario by the school board trustee, it's sort of the provincial level. The provinces and school boards, are they putting more money aside for copyright? Is it staying the same? That's one of the questions that we had was, how is copyright being funded, and are there mechanisms in place for the province or the school board in that district to put more money into copyright?
So as a whole, on purchasing materials, the number of dollars that we're spending is going up in terms of purchasing materials into our education systems. We are, as the Council of Ministers of Education Canada, collectively putting forward $5 million to enhance education around copyright, and to, as I mentioned earlier, do further assessment on compliance with the rules around fair dealing.
Thank you. That's it. We're good.
Thank you.
Monsieur Bernier, vous avez 5 minutes.
Merci. Je veux juste revenir.
Thank you. Let me come back to the question of funding. My colleagues asked various questions about the cost for you. I'd like to know, on average, how much do school boards spend, and how much have they spent since 2012 for copyright each year? And the committee has had a question right from the beginning of these hearings. After the new Copyright Act, did that amount go up or down, and by how much? Could you please clarify those numbers for us?
So since 2012, and we do have the numbers from Statistics Canada in your packages. The sales have gone up to the publishing industry in the K-12 or P-12 education system. So if you look, book sales have gone up from 2012 to all the way up to 2016, and you see those numbers detailed in each of those graphs there.
So do you think that you save some money at the end, or you're paying more for these rights?
We're paying more in materials,
Yeah.
but the nature of those materials is changing. So we are, investing more in course materials in our education systems. What we're worried about is a mandatory tariff that would take, if accepted at what the proposal is, take approximately $53 million outside of our education system as a subsidy to the industry. So that is something that we are concerned about, because and that number is not reflective of Quebec. That number is reflective of all the provinces involved in the consortium on copyright. But that is where we do have a concern, because those dollars are precious. That is the equivalent of hundreds of teaching positions, specialized resources in our classrooms. That number will have an impact on education delivery for our students.
So your point of view is to keep the statu quo and what the court decided as the definition for fair dealing. You're comfortable with that?
We do support the court defined the court definition for fair dealing. It's not an easy question to answer, and I think the courts have done us a service in terms of tackling that important question over the course of 10 years. And so, I do think practically it makes sense that if you're only photocopying an excerpt of a text, a chapter, or an amount that does not exceed 10% of the text, that we're able to use those resources in the classroom to make sure that our kids have access to as wide range of information as possible.
So do you think that we need a more defined definition in our own legislation to reflect the court decision, or?
We're not advocating for any changes to definitions in the Copyright Modernization Act that were brought in 2012. We do believe that the case law has done that work for us.
Do you want to add something? No. That's it. Yeah.
Mr. Longfield, you have 5 minutes.
Thank you, Mr. Chair, and thank you for being here, both of you. I want to build on where Mr. Bernier was going with some of those questions. We've seen, we can see from the curve the volume, the dollar volume increasing. But what we don't see is, well, several things that we don't see is how much is going towards copyright fees within those dollar numbers. Another way of saying that might be, what's the average unit price of the books? Is that going up? But are we actually reimbursing authors through publishers, through distributors? Are we getting the collection done of fees to go to the creators?
If I may, the answer to that question is based in the contracts that are entered into between publishers and authors. They divide up the pot, and that would vary on how prominent and important the author is. The prices are set, and the education system doesn't have any control over that. Right. The publisher and author divide up the pie.
Understood. But you can see where I'm getting is, and you may not be able to answer this because it's maybe for the publishers to say, but the dollar volume really doesn't get to the root of the question that we're looking to try to answer. And that's something that we've been a little frustrated as a committee of trying to get into the supply chain to see exactly where are the leakages. When we talk about a 2% leakage on legitimate copying versus non-legitimate copying, what's the dollar on 2% of the whole? Like, we're not talking about 100 pages here. We're talking about millions of pages that the school boards would be copying. And 2% of that figure could actually be a pretty substantial number. Would we know what 2% leakage costs?
So we actually have done the math on that, and that would be, if you're looking at per student, that would be 2 copies per student per school year. So 2 illegal copies per student per year. Yeah, looking at that 2%.
We've certainly had contrasting opinions from other witnesses on how many copies are.
And that's based on the, so say if we accept the $600 million or 600 million copy figure that's been presented, if you look at 2% of that, I wasn't a math major, by the way.
Okay, that's okay. I was.
But what we've come up with is less than 2 copies per student per school year.
What about the cost of administering the current program? You're mentioning $5 million in advertising costs. There's posters being printed that are being put above photocopiers, and I'm guessing if the way people are is you'll see the poster, you may or may not read it. The second time you won't even see the poster. But there's costs that are being put towards trying to administer the existing program. Those costs could be taken away if a standard licensing fee was charged that would be equivalent in dollar value to what the hidden costs are in terms of reimbursing publishers or authors. The cost of the existing program, do we have any idea of how many person hours goes into administering programs, teaching people about copyright requirements, policing the services, the auditor costs that you're using? Do you know how much it costs to administer the existing program?
So as ministers, we do have an obligation to inform our educators of the law and ensure that there's compliance. So that, that's not just a cost associated with copyright, that's a cost associated with the variety of rules that they have to function under. In terms of us quantifying how much money we're going to spend in resources to educate and to further assess compliance, we have that number at $5 million, which is drastically lower than what the figure, 50 plus.
That's a Nova Scotia number, or is that a national number?
That's a national number.
Okay. Yet to be convinced, but back over to you, Mr. Chair.
Before I move on, I would just like to have a point of clarification. You had mentioned 2 copies. Is that 2 pages or is it 2 works, copies of works? Do you have an
Pages.
idea? Pages, 2 pages.
2 pages.
Okay, thank you. We're going to move to Mr. Genereux. You have 5 minutes.
Perfect. Thank you, Mr. Chair, and thank you both for being here today. So throughout the testimony back in 2011, the education testimony, many representatives of the education sector explicitly stated that institutions would not stop paying licensing fees to licensing collectives like Access Copyright and Copyback if education was included under fair dealing. On December 5th, 2012, a new act came into force. Access Copyright was served with a letter from you, Ms. Noel, on behalf of CMEC and the Ontario School Board, saying that they would no longer be complying with the tariff regime. Can you explain this discrepancy between the testimony in 2011 and the 2012 letter to Access Copyright?
Certainly can. Your colleague beside you asked the same question. The decision to no longer rely on the Access Copyright tariff, but other sources of copyright clearance, has nothing to do with the adding of education to the list of purposes for which fair dealing can be engaged in. The decision to not pay the tariff is based on the Supreme Court of Canada decision only. If the Supreme Court of Canada had issued a decision that was different from the one it did, there would have been no opting out of the tariff system.
So,
Prior to that sorry.
No, go ahead. Keep going.
I was just going to say, prior to that decision, it was not clear whether a teacher could make a copy of a short excerpt, a little bit was what the terms that were being used, for each of the students in their class. And the argument was about, it's called multiple copies for classroom use. You've got a classroom with 30 students in it. You want a copy of a newspaper article. Can the teacher make a copy for each student in the class? It was understood up until that Supreme Court decision, or thought, that you could only make 1 copy, that multiple copies for a class of students was not allowed. That decision had a profound change on the law of fair dealing that had nothing to do with adding education as a fair dealing purpose. And that happened in July, the Supreme Court decision. The opt-out was the following January 1st.
Okay, so we go back to specific things that were said by Universities Canada. I have the quote in front of me. I won't, due to time, I won't bother reading it into record, that said that absolutely under no circumstances would they be opting out of this. So I guess trying to get you to take us back to where this was said in front of committee, and then you issue this letter to CMEC. I'm trying to understand what happened from that moment to this moment to now, essentially putting us to where we're at today.
Okay, I'll try. When the education was added as a fair dealing purpose in 2012, that was in the spring and summer. We're in Parliament. The question to Minister Jennings was, will adding education to the fair dealing provision as a new purpose, will that have any impact on you paying rights holders? Her answer was no, it would not, nor did it. And then, fast forward to a Supreme Court decision that interpreted fair dealing far more broadly than anyone ever anticipated. What the decision was, copying for student instruction is fair dealing as long as the excerpt is short. And that was a much broader interpretation of fair dealing, and that in turn, 6 months later, led to the decision not to take up the access tariff any longer because it wasn't providing value for money. There were millions and millions of dollars being spent for a license that didn't have any value anymore because of the Supreme Court decision, not because of adding education as a fair dealing purpose.
Okay, I know that we'll have I have 1 minute left, so we'll have Access Copyright in front of us later, hopefully to clarify some of that. Do want to just get from you, Mr. Honourable Minister Churchill, how much money do Canadian schools and school boards on average spend each year to acquire copyrighted works in proportion with their total annual budget?
I don't have that number for you, but we'll see if staff can provide that to the committee.
Well, okay, perfect. Mike, okay.
Thank you very much. We're going to move to Mr. Jahari. You have 5 minutes.
Thank you, Mr. Chair. I'm going to split my time with Mr. Bailey's. Thank you, Minister, for coming. Minister, CMEC published its own fair dealing guidelines. Can you help me understand the process through which CMEC went through to develop those guidelines, and who did you guys consult with?
Well, Ms. Noel was there for that process, so I'll allow her
Great,
to answer
sure.
very specifically to that.
When the Supreme Court of Canada decision came down in 2012, interpreting fair dealing broadly to say copying short excerpts for student instruction was permitted or was fair, we were faced, we being legal counsel for colleges, for universities, and for the Council of Ministers of Education, were faced with a situation where we had to put some meaning around what is a short excerpt. Because the Supreme Court said you can copy short excerpts for students in a class, but they didn't say anything about what short excerpts were. So there were a number of sources that guided us in developing the limits that are in the fair dealing guidelines. On the same day that the Supreme Court decided how fair dealing should be interpreted in an education context, they issued another decision which interpreted fair dealing for the online sale of music. And in that case, they did put some numbers around the amount that could be copied under fair dealing. And in that case, they had, it was previews. When you buy music online, you can preview it, you can listen to a piece of it. So 30 seconds, it was 30 to 90 seconds of a 4-minute song. Now, at 30 seconds out of 4 minutes, that's 12.5% of the musical work. So that was one source. We also were looking at case law in the United States, where, as there is here in Canada, a dispute going on between publishers and a university about how much could be copied for the use of students. In those decisions, which has now gone up to the Federal Court of Appeal, back down on reconsideration, and back up again with no decision yet, the threshold of 10% or a chapter was used many times in the court decision, finding that that threshold was fair.
So let me
Now,
ask a very
I just want to
specific-
make one other point, because the fair dealing guidelines are a conservative interpretation of short excerpt. And why they're conservative, there was around the world, if you want to go outside of Canada, in Israel there was a dispute between the higher education community and publishers. And there, the threshold is 20% of a work.
So as part of your review and development of the guidelines, did you talk to content creators to get your input of what fair dealing means?
We were in years of litigation with them. No, we did not, because there was no possibility of ever coming to an agreement. There still isn't today. That's what's before this committee.
Okay,
No.
thank you.
I just want to delve in quickly on your statistics. Very interesting, but I'm concerned that might be a little misleading. When you did this, you used Statistics Canada. Did you get it in what we call average dollars? Did you put it back in same dollars?
Constant dollars?
Constant dollars?
Yes.
This is a constant dollar chart?
believe
that-
so. I
that
asked
you
the same
applied-
question.
that you applied the inflation rate against it?
Constant dollars was the answer I was given to that question.
It doesn't tell us what dollar then. It also, I can see there's a mistake here too, so that's why I started wondering about, it says here 66% of all Canadian sales are book sales, that's a bracket there. I've just done the math quickly. I can't find anyone that's 66%. This was led me to question some of your math here. Are you absolutely certain it's in constant dollars or not?
Well, there are statisticians that work at the Council
I
of
know there are.
Ministers.
I'm just asking.
I'm not one.
Yeah,
But
but they
produce
made a
this.
mistake on one point here, so I'm just asking, can you confirm that to us, it's in constant dollars?
I asked the question, that was the answer. Yes, it is in constant dollars.
Can you provide it then as a reflection against they also have a consumer price index specifically for education, how these numbers reflect the changes with respect to education?
If StatsCan
The
has
consumer
data
price-
on that, we could do it.
StatsCan does have data on consumer price index specifically for recreation education. And if you could compare that to that index, how these are changing with respect to that index. And if you could tell us, you said they are in constant dollars, perhaps you could tell us which one. And you could
So
also,
how changing with the CPI was one, and
well, you said this
what dollar is
you
the
said,
constant
yeah,
dollar?
it's constant dollars. And if you said here, maybe I misunderstood it, it says it's 66% of all sales, maybe that's correct too. I couldn't do that math. If you could have that clarified first as well.
and what would the clarification be on the 66%?
Well, it says here, these are the book sales in Canada, these are book sales in Ontario, and brackets, this accounts for 66% of all Canadian sales. I just did the math, say I multiply it by this number, by that number, it doesn't add up.
All right, well, I'll get that out of Hansard and pass it on to the statisticians then. See if I can get the answers.
So, 3 questions. Which constant dollar it's in, number one. Number two, could we have this comparison against the rate of change here versus the rate of change in the consumer price index, specifically for education? So seeing how much of your education budget, is it constantly what you're spending in Canadian books, or is it going down or staying the same? Do you understand?
I can get your exact
Yeah,
question out
so
of
you'll,
Hansard.
that's it. And the third one is maybe I've misunderstood something here, but if you can clarify that too.
Thank you. And for the final 2 minutes, Mr. Massey.
Follow up with your 2 copies per student, just to get an idea of where that came from in terms of the accumulation of that data. And then also, too, is that have you had, I guess, specific cases where there was significant copywriting, and then what were the repercussions to the people that were doing that? What's your kind of policy on that? So how did you get the numbers, and then how do you, I guess, I mean, that's a there's many students, I'm sure, that do any copyright infringement, but have there been major cases, and what happens to those individuals with regards to those cases?
Thank you very much for the question. So that number comes from the $600 million, 600 million pages that the industry has told us are being made free every year in Canadian schools. So if you use that number,
Okay.
again, we don't know if that number is accurate, but you look at 2% of that based on the Copyright Board of Canada and the Federal Court of Appeal saying 2%. Only 2% of copying is falling outside of fair dealing. You look at that's 12 million copies. We have 7 million students, so that's approximately 2
Okay, so
copies
yeah,
per
you just
student per
applied
school
their
year.
own numbers, and the veracity of their own numbers are really, it's their own data.
That's using the data from the industry.
Yeah, accepting the premise.
Yeah.
Of it. What about in terms of do you have a like is a province by province the repercussions with regards to copyright infringement and in any rate?
The mechanisms in place for performance issues or disciplinary action does differ from jurisdiction to jurisdiction, even specifically sometimes from board to board.
Yeah, school boards. Okay. Yeah. Okay. Thank you, Mr. Chair.
On that note, I would like to thank Ms. Noel and the Honourable Zach Churchill for being here today with us and answering some pretty hard questions. As you can tell, we're a very inquisitive group over here, and we're trying to get to the core of this. So I want to thank you both for coming and speaking with us today. We're going to suspend for a very quick minute while we change over our panels. Thank you very much. Everybody. For the second hour of fun, we have with us from Copybec, Frédéric Couette, Executive Director, and from Access Copyright, Roanie Lévy, President and Chief Executive Officer. We're going to start with Copybec. You have up to 7 minutes. Vous avez 7 minutes, s'il vous plaît.
You have 7 minutes, please. Hello, thank you for having us here today. My name is Frédéric Couette. I am Executive Director of Copybec, a copyright collective. Created in 1997, Copybec is the copyright collective of Quebec authors and publishers. We are a nonprofit. We collect royalties and give them to authors, freelance journalists, and other creators after paying our management fees. 6 years ago, we appeared before the Committee on C-32. We warned the committee against the risks of the use of the education exemption. Representatives of the educational sector said that they would never end the use of licenses with copyright collectives. They said that this would have no tangible negative effects for copyright holders. And yet, as of January 2013, these same organizations started ending their agreements with Access Copyright. And since then, things have only gotten worse. They have created new copy policies which allow for copies of a chapter or 10% of a work as much as possible in order not to have to pay royalties to copyright holders through copyright collectives. Education ministries outside Quebec would even prosecute rights holders through Access Copyright, despite the fact that the royalties they should have received were minimal. In Quebec, the situation is worrisome. The University of Laval, in June 2014, decided to use the same approach as that used by other universities elsewhere in Canada. Other Quebec educational institutions still work with Copybec, but each time that the agreements are renegotiated, royalties are further squeezed. Royalties paid by each student have gone down by 50%, going down from 25% in 2012 to $12 in 2017. And in CEGEPS, the amount has gone down by 15%. Unfortunately, our fears have become a reality. Royalties are decreasing rapidly under the pressure of the educational sector. There are more and more legal proceedings, while the value of copyright is constantly being reduced. While Copybec has kept its management fees at 15%, royalties paid to creators and authors has decreased by 23% for each page copied by universities. Universities have told you about the millions of dollars they spend on their acquisition budget to pay for foreign scientific journal publishers. And yet, at whatever level of education, the copies that are made are in great part for books rather than foreign journals. And it is not these major journal publishers that are suffering from this decrease in royalties, but rather our small local publishers. And these are the ones for whom royalties represent up to 18% of their net profits. For some book publishers, royalties can even represent up to 33%. This contributes significantly to allowing specialized journals to survive in both Canada and Quebec and can make all the difference between bankruptcy and success. This precarious situation is causing revenues to decrease on this important link in the publishing ecosystem and is decreasing the capacity of authors to create. The Quebec experience is a significant model of collective copyright management. I wouldn't say that it's a panacea. That's not true. In fact, if nothing is done to rectify the disastrous effects of the 2012 changes, the situation in Quebec will only get worse, with a gradual decrease in royalties, which may disappear entirely. Currently, Quebec University students spend $13.50 a year for the Copybec license. This represents less than 0.5% of their total annual tuition for the average student. Additionally, the agreements signed with the universities, they're signed with universities, not students, means that the universities don't have to pass off the cost onto students. For a university like Concordia or the University of Montreal, this would represent, for the 2017-18 school year respectively, would represent 0.08% and 0.07% of their annual operating budget. Tuition fees are not higher in Quebec than elsewhere in Canada. Paying royalties for the reproduction of extracts of works has never imperiled the Canadian education system and has never increased student debt. We mentioned the fair dealing exemption. You have been told that the fair dealing exemption is the only way to make these works accessible, but this is not borne out by the data. However, we know that copyright collective management has always enabled works to be accessible, including digital works, thanks to agreements signed with members of the International Federation of Rights Holders. In order to ensure that the legislation be balanced, copyright collective management balances accessibility to works with fair payments to rights holders. It leads to not only immediate access to knowledge, but also the preservation of cultural diversity and creativity for tomorrow. Collective rights management is an essential pillar of a modern system of copyright protection which can compete effectively and become part of a system of cultural development. We must protect royalties for authors and publishers. Additionally, the International Declaration of Human Rights states that work deserves fair payment. Copyright is intrinsically linked, additionally, to authors' freedom of expression by allowing them to obtain to earn independently and express their thoughts independently. Mr. Chair, members of the committee, thank you for having listened to us today. And I would like to say that this is part of a modern approach. We must be part of a society that invests in its future in the digital age. The model that we recommend is a contemporary one, not an outdated one, and will allow us to create a contemporary creator society. Your decisions at this stage will have a fundamental impact on the future of the book sector and the publishing industry and cultural industries in Canada. In conclusion, I would like to quote a passage of the Strategic Creative Framework 2017 on copyright. The copyright framework is an essential part of the creative economy and will continue to be so. Under an effective copyright regime, creators must be able to draw revenues from their works, and users must continue to be able to access a wide range of cultural content. Collective rights management is part of this approach and must be supported by Canada's cultural policy. Thank you. Thank you very much. And now Ms. Levy, 7 minutes.
Invitation to appear before this committee. My name is Roanne Levy, and I am the President and CEO of Access Copyright. Access Copyright is a not-for-profit copyright collective created in 1988 by Canadian creators and publishers of textbooks, trade books, newspapers, magazines, and journals to manage the reuse of their works. The copying that creators used to get paid for is now being done for free under so-called fair dealing guidelines. These copying policies reflect the education sector's interpretation of fair dealing and were developed without the input or support of creators and publishers. These copying policies, which mimic the copying limits that had previously been paid for under the Access Copyright license, effectively replaced the collective license with an uncompensated exception under the guise of fair dealing for education. The outcome? 600 million pages of copyright-protected content is being copied for free each year by the education sector. This is content that is not licensed through academic libraries or made available under open access licenses. royalties collected by Access Copyright from the education sector have declined by 89% since 2012. Historically, these royalties represented 20% of creators' writing income and 16% of publishers' profits. The estimated loss of licensing royalties to creators and publishers due to the education sector's interpretation of fair dealing is $30 million a year. To this loss, we must also add the loss in primary sales due to substitution effect of free content copied under the education sector's copying policies. I've structured my remarks today around 4 questions, which I hope will be helpful to the committee. 1, when the Act was amended, was it Parliament's intent to eliminate the collective license and replace it with an uncompensated exception? 2, are the copying policies supported by the teachings of the Supreme Court of Canada? 3, are the copying policies damaging to the writing and publishing sector in Canada? And lastly, what should the true purpose of fair dealing for education be? To learn what was intended and understood by the addition of education to fair dealing, it is useful to refer to the representations made by the education sector during the legislative hearings on the bill. Representatives from the education sector repeatedly and emphatically assured the legislative committee that the changes would not result in the education sector stopping to pay for the copying of works. Fair dealing for education, according to their testimonies, was not going to replace the collective license. For example, Paul Davison, president of Universities Canada, said, in particular, it has been suggested that the education community does not want to pay for educational materials, and that Bill C-32, especially the addition of education as a new fair dealing purpose, will undermine the publishing industry in Canada and decimate the revenues of copyright collectives such as Access Copyright. These claims are false and not supported by the facts. End of quote. Similar assurances were made again and again by representatives of the elementary and secondary sector. We are not asking for anything for free, was repeated numerous times. The Honorable Ramona Jennings, as was mentioned earlier, came before the Legislative Committee and said, quote, nothing in Bill C-32 alters the current relationship among education, publishers, content providers, copyright collectives, and the Copyright Board. Although replacing the collective license with an uncompensated exception was not intended with the introduction of education to fair dealing, we now know that that is exactly how the education sector acted following the coming into force of the Copyright Modernization Act. Educational institutions across the country, except in Quebec, adopted copying policies that encourage the mass, systemic, and systematic copying of protected works without payment to the creators. Once these policies were adopted, most educational institutions walked away from their long-standing license agreements with Access Copyright. So if the copying policies were not intended by the changes to the Act, are they in keeping with the decisions of the Supreme Court that you heard about earlier today? So following the adoption of the copying policies, the creators and publishers' only recourse to clarify fair dealing was to bring the matter to the courts. That is why Access Copyright sued York University. In a decision issued in June 2017, the federal court unequivocally concluded that the copying policies and practices adopted by York University, which are virtually identical to the policies adopted across the country by educational institutions, including the K-12 sector, are, and I quote, not fair in either their terms or their applications. The guidelines do not withstand the application of the two-part test laid down by the Supreme Court of Canada jurisprudence to determine this issue, end of quote. The copying policies are not in line with the Supreme Court of Canada's teachings. So do they harm writing and publishing in Canada? The York case involved a 4-week hearing, 4 weeks, during which time the federal court judge heard extensive evidence, including the evidence of dueling economic experts. They were presented by both sides. The court looked at York's copying policies and their impact on creators and publishers. After careful examination, the judge found that the policies are arbitrary and unfair, and ultimately result in an unfair, quote, wealth transfer from creators to educational institutions. Importantly, the court concluded that, quote, any suggestion that the guidelines have not and will not have negative impacts on copyright owners and publishers is not tenable. Not tenable. It is important to note that this decision is the only court decision or copyright board decision that examines the fairness of the copying policies. There are no other decisions by any court that examines whether 10% or a chapter is fair. Only this one. So what then should be the true purpose of fair dealing? Here again, I think it is instructive to go back to the representations made by the education sector during the legislative committee. Here's the first example. Steve Wills, at the time manager, government relations and legal affairs for University Canada, stated it clearly. Quote, first of all, in regard to the educational community, nothing in Bill C-32, for starters, is going to change the revenue going to collectives such as Access Copyright and Copyback. It's not about saving money. What it is about, the change to fair dealing in particular, is allowing certain educational opportunities that right now sometimes don't occur. The Honorable Ramona Jennings also helps us understand what the true purpose of fair dealing should be. Quote, we are not asking for anything for free. The education system, the sector, pays for licenses and copyright and will continue to do so. What we're asking for with these amendments is to have things clarified. The true purpose of the 2012 amendments, as represented by the education sector to the legislative committee, was to clarify that fair dealing can be relied on by educational institutions when the copying of a work is not covered by licenses or easily available through the rights holders, not to do away with collective licensing. We urge the committee to recommend that this be clearly stated in the Act. As the litigation endures, uncertainty around what can be copied challenges educators every day. Creators are deprived of a significant chunk of their income, and educational publishers are making tough decisions. Publishers are leaving the educational market, resulting in lost jobs and significantly reduced investments in the creation of Canadian content. This, in turn, means fewer opportunities and reduced income for creators. At the end of the day, we all lose when Canadian creators and publishers do not have the economic incentives and ability to continue to create content that reflect who we are, our experiences, and values as Canadians. Thank you.
Thank you very much. We're going to move mindful of the time. Mr. Bayliss, you have 6 minutes.
Thank you, Chair. Merci, Madame Cott. Thank you, Ms. Levy, for being here. Question, we're hearing from two sides of, on one hand, the universities come in there and the representatives saying we're paying more and more and more. And on the other hand, we're hearing from authors, publishers, and yourselves as your association saying we're getting less and less and less. Can you help clarify? Do you agree with that? Are they paying more? Are you getting less? If so, what's happening?
We don't dispute that the university sectors may in fact be paying more and more for content. But what's important to keep in mind is that the content that they are licensing and paying through their library licenses is different from the content that they are copying under their copying policies. We're talking about two different buckets of content. There's some overlap, but very little overlap. The content that they are licensing is through their own testimonies before you, mainly journal articles, As an example, CRKN testified that out of $125 million, 122 is spent with foreign publishers. That content is content that is created often by academics, people that rely on a salary in order to be compensated for their contributions. The content that is copied under the Access Copyright or historically under the Access Copyright license, today under their fair dealing guidelines, is mostly books, not journals. This is content that is created by professional authors who rely on royalties for compensation. It is not content that is licensed by and large by the library through the library licenses. Two different buckets of contents. The Canadian content that is adapted and customized, that tells our stories, is in that B bucket, the content that is being copied today for free.
Fair dealings, whatever way it's applied or not, the idea is to give a bit of oil in the system to let people, if I got to make a couple copies of a book of that. Is Access Copyright, are you looking to clamp, do you want to make money, monetize every single copy, or are you against, can you give us your view of what fair dealing should be? You're not happy with what it is, so what should it exist, number one, and if it does should exist, how should it exist?
Yes, fair dealing should exist. So we're not arguing that fair dealing be removed. But what's important to keep in mind is that the fair dealing needs to allow a market to take place. The way it's being applied today doesn't allow the educational market to survive. I think we could be inspired by the way fair dealing is used in other jurisdictions, such as in the UK and Australia. The outcome in those jurisdictions is the copying that is done by the institutions, by the educational institutions, is not allowed under fair dealing. If there's a license, it has to be paid for. The copying that is done by the students, the self-generated reproduction of works, that is fair dealing. And that's what we see in Australia and in the UK, that both have fair dealing provisions. The mechanisms to achieve that is different in the two jurisdictions, but that is the bottom line outcome.
They allow the students to say fair dealings for the students, but the institution has to pay.
That's right. So the systematic mass copying that happens by the institutions, for example, the copying of chapters and 10% that get loaded in our learning management system, that gets reproduced in course packs, that substitute for the purchasing of books, which is what the conclusions of the judge were in York, that should not be fair dealing.
Madame Coët, Madame Lévy vient de nous donner un exemple.
Ms. Levy just talked to us about Australia and the UK and said these have solutions. Would Quebec agree with that? What's your perspective when it comes to solutions? Well, we share that vision with Access Copyright. We have the same point of view. We think we should imitate the type of provisions there are in the UK and also in New Zealand. There are provisions there that state that once a license is in place, and in Section 2, there is a provision regarding accessibility on the market, which is already used to limit certain exceptions for education, for example, which could be extended to Section 29. And so there's the notion of reasonableness at the very heart of this. So at that point, Section 2 states that if a license is available and that it's at a reasonable price, able to be found with a reasonable effort within a reasonable time frame, that does not enable fair dealing to be applied, and that would limit the use of fair dealing for institutions. It means that it would allow students to do their own personal research for homework, whereas institutional use would be covered by the license.
No, Monsieur Bernier.
Merci beaucoup. Je vais partager mon temps avec...
Thank you very much. I'll share my time with Mr. Genereux. I have a question for Ms. Coët. Do you agree with what Ms. Levy said earlier regarding how universities use copyright for copies in libraries and also regarding students' classroom use. Do you agree? Are you talking about the sharing of license versus acquisition? Yes. Well, we still have our licenses with universities, so we still receive the university's reports, and 80% of the use is books. What the licenses cover are not international publishers. And the sums we send to these international publishers are merely spare change for these huge companies. The real place where we've seen a decrease in revenues is our local and Quebec publishing companies. So when universities tell us that they're paying more and more for copyright, on the one hand, this may be true, and you're saying that your revenues are decreasing. Is that the explanation you'd give? Yes, they're saying that they're spending more on acquisition. That's why they're spending more, whereas they pay us for reproduction. Regarding solutions, you said earlier that you admire the UK legislation as well as what they have in other countries. Do you think we should keep fair dealing in the legislation for the education exception? Should we just modify it, or should we even go back to the way it was before and not include the educational exception? We believe that, fair dealing has always been in Canadian legislation, and collective rights management organizations also are part of legislation. It's part of the balance. However, the way the educational exception is interpreted today, it's the way it's interpreted by universities that's causing the problem. If we move closer to the methods that are used in Australia, New Zealand, and the UK under their various forms, that will enable us to strike a better balance and to get more royalties when it comes to institutional mass copying. Do we need to make the criteria stricter and not merely rest upon the interpretation made by the courts? Well, when it comes to the court's opinion, Ms. Noel told you earlier that she was basing herself on the 2012 ruling in Alberta against access copyright. In that ruling, it was never said that you could use 10% or a complete chapter of a work. The ruling spoke of 4.5 pages per year per student. That's much less than 10%. In Quebec, 47 million pages, 22 million for CEGEPs, 10% of primary and secondary schools, 36 million. That's much more than 4.5 pages. And the Supreme Court also stated that the 17 million pages fell under fair dealing, but that schools were paying for the rest, but now they do not pay for the rest any longer.
Yeah, my colleague's line of questioning. You heard Ms. Noel's comments earlier, give you both a chance to comment on what she said, but in particular with regards to, if you can take us back to 2011, we have the testimony, you read some of it into the record, Ms. Levy. What then suddenly are you blindsided by a letter from Ms. Noel on this? I guess take us back to some of before December 5th, 2012.
When creators and publishers came before the Legislative Committee in 2011-2012, looking at the Copyright Modernization Act, we were very concerned that the addition of education was going to lead to exactly the situation we're in today, with the education sector abandoning all the licenses. But the education sector, time and time again, came to the committee and essentially said that the creators and publishers and the collective were fear-mongering, that in fact that was not at all what it was intended. It was really for these other uses of other works that are not covered by the license, essentially, that the license would continue to remain whole, that they would pay it. So Are we completely blindsided? Well, we were always concerned that we were going to get to this point. So not completely blindsided, but are a little bit surprised that they did such a quick turn on their position.
Madame Goette, any comments on Ms. Noel's testimony earlier?
On a eu la même situation dans le sens où
We had the same situation in the sense that we saw that as of July 2012, Quebec universities asked us to renegotiate. So they didn't end the licenses. But even though we had just finished renegotiating in May or June of 2012, the adoption of the legislation took place at the end of the month. And then in July, there was the ruling of the Supreme Court, and Quebec universities asked to renegotiate the agreements. So in January 2013, the license went from 25.5 to $21 rather in January 2013. So we also felt the effects after the provisions were changed.
Mr. Chair, and thank you for your testimony today. Just want to get clarification with regards to the illegal copying that's taking place. I've heard different numbers in that. What exactly are they, and then where did the numbers come from? Those have been used by several witnesses prior to today's testimony as well, too. So, but I think that they're all using these numbers, the 600 million.
Yes.
And then there were some other ones, but where does that come from in terms of the?
Sure. So there is a document which I distributed that got distributed earlier, and it's got some of the key numbers in there explaining where they come from. So you'll see where the $600 million pages of published works copied every year comes from.
Where does that? Well, for the record, where exactly does that come from?
So it comes from a couple of places. Yeah. So the first place is the Copyright Board decision in the elementary secondary school sector. There were 380 million pages copied there per year per student.
How did they come to that conclusion?
A study was done.
Okay.
So there was a study that was done.
I just want to make sure, because we're hearing that number quite a bit, so if people aren't following it,
Absolutely.
they want to know the...
So a study was done, and that's where 380 million came from. Of that 380 million, the Copyright Board concluded that 60% of that is fair dealing and therefore not compensable. Okay. And the remaining 40% is compensable. So in fact, there was 150 million pages that still need to be compensated, but the ministers of education are still refusing to pay that. So they're claiming the whole thing under fair dealing, even the amount that the Copyright Board said had to be paid for.
So there's about 150 million of not the really outstanding invoices.
Outstanding payments that they're claiming fair dealing on, 380 total for elementary, secondary. In the post-sec sector, we did a study in the York University case.
Yes.
And in that case, as a result of this studying, which looked at the copies that were loaded on learning management systems and course pack, we see 360 pages per student per year being copied on average.
Okay, so
when you use all of that data on a conservative end, you end up with 600 million pages that are copied and not paid for. And these are copies that are not licensed. No transactional licenses have been obtained for it, that are not available under open access licenses either.
Would it be fair to say that as educational, age and grade level increases, that the increasing amount of copyright takes place?
Yes.
So that, I don't want to draw assumptions, but I think that I'm not going to read the studies. I'm not.
Yes, no, absolutely.
But that's why. So that's where the particular problem is. Now, has that increased, and is there any data related to that since the decision's been in place in terms of has the behavior pattern changed with the decision? So outside, let's put that aside in terms of it. Has that increased? Has there been a pattern of behavior? Do we know? Or this may not be fair to you, but I'm trying to get some scope of what's taking place.
It's hard to tell because we had historical data about what used to be copied, at least part of what used to be copied, because before 2013, when they stopped paying, in the post-sec level, they would report to us all copies that were made and included in course packs, in paper course packs. Today, we don't know what gets copied anymore. What we do know is only from the study that we did with York University in the context of that litigation. And in that context, 360 pages per student per year were copied.
And that's going to be pretty onerous too with digital and a series of different formats changes that are more dynamic than ever before. So I can appreciate that. That helps. Now, with regards to many of much of the testimony we have, and we hear, and you heard some of this today, is that an incremental amount of money is being spent on materials. You're mentioning that Canadian publishing firms in Quebec are down. So is this basically what's happening, is most things are being streamed to 3 to 5 publishing conglomerates? Is that really what's taking place? And or are they not really telling the full story here, that their costs for publications is actually going up?
So they based on what I heard in their testimonies, and they're in a better position to tell you how much they spend, they are increasing spending on journal articles. So this is research material by and large, not instructional material.
Okay, yeah.
So the material that gets used, that tends to get copied and used in class for instruction, is different from the material that is used for research. So that's where you get the science, technical, medical journal publishers, the 5 big multinational publishers are in that category. Yeah. The licenses that they have through CRCan, those are the STM, science, technical, medical journals. What gets copied and no longer paid for is the educational content, is the trade content, is the stuff that is used for instructional purpose. Yeah. So similar to what Frédéric mentioned about the experience in Quebec, in the rest of Canada as well, what we saw historically is that only about 15% of the copies that they used to historically make and report to us was from STM, Science, Technical, Medical Journals. The rest was books, and that doesn't tend to be licensed through university libraries.
That's very helpful. Do I have any time left?
15 seconds.
Oh. Thank you very much. That's been very helpful.
We're going to move right to Mr. Longfield. You have 5 minutes.
Thanks, Mr. Chair, and thank you both for coming with detailed information for us. We are trying to get to the bottom of what's fair, and not just fair use, but what's fair in terms of legislation. Mr. Massey mentioned earlier that when it ends up in court, that means we haven't done our job. We've had 21 hearings since the new legislation's come in. What was the relationship before that? Did you have hearings? You're both involved with litigation right now, both of your organizations, class action in one case, in another case, the litigation against licenses that weren't being paid. What was it like before this legislation? Is this better or worse?
Pour ce qui concerne Copybec, on a toujours...
With regard to Copybec, we have always negotiated our license agreements. We've never gone through the Copyright Board or through legal proceedings. We have always preferred negotiation. And today, that's still what we prefer with all the universities except for the University of Laval. Because in 2014, Laval University refused to negotiate it. They'd never wanted to sit down at the table with us. We had no choice. That's not our preferred method when it comes to negotiating royalties. But we have been faced with this situation since 2012 with Laval University.
I've been at Access Copyright for 17 years, so I've been there in a way through this whole process. And what I'm going to express is my personal view of what has happened through the years. The Copyright Modernization Act took 15 years. So for 15 years, the parties came before committees, sometimes legislative committees, some standing committees, sometimes legislative committee, to look at another iteration of the Copyright Act. And you had the creators, the writers and publishers and the collectives on one hand, and you had the education sector on the other hand. Creators and publishers wanted stronger copyright, and the users, and in our situation, the education sector, the libraries, wanted more exceptions. So we were at odds with each other for 15 years. And in the context of that tug of war around what the Copyright Act is ultimately going to say, big licenses came up for negotiations. And it became increasingly difficult for us to sit down at a table and negotiate the license. And that's why we ended up before the Copyright Board. And As the process continues with these 5 years reviews and litigation that takes almost a decade to conclude, we are stuck in this tug of war.
Right.
It is not our preferred situation.
Right. I should have mentioned I was going to share a minute of my time with Mr. Sheehan, but I'm just going to touch on this just a little bit further because I think we're onto something when it comes to licenses. That the intention at the time was that it would be revenue neutral. Licenses would continue to be paid. Users would be able to have access for the purpose of studying and education. Institutes would continue to pay licenses on behalf, knowing that students would have access to the material to copy in terms of their studies and research. And then at some point we came off the rails, that the licenses with the institutions weren't getting covered off. Is that a fair assessment?
Je vous dirais que je pense que l'exemple québécois.
I would say that the Quebec example shows a type of balance. With a 1350, I wouldn't say that's a fair amount of royalties, but at least we can negotiate. And the only reason that that happens in Quebec is that we have a Ministry of Culture, Ministry of Education, and these ministries care about ensuring the future of a strong publishing industry, which tells Quebec history instead of looking to France, Belgium, or elsewhere. So if we don't have a way to guide universities and ministries of education when it comes to interpretation, we end up with a lack of balance and there is too much access, and that is what the situation we'll find ourselves in.
Quickly, on the tour, UBC had shown us a chart where course packs used to be 80% usage and 20% were digital. And just recently they did a study, and the number absolutely flip-flopped on that. So as it relates to digital form and the transactions that are happening, a lot of the universities are opting out of access copyright, et cetera, et cetera. Question I have is, could there be a situation where Access Copyright would sue a university or content purchaser for use in your repertoire, but they had already and legally received permission to use elsewhere?
I think that's a hypothetical, and I can't really answer a hypothetical, especially when it involves suing someone. But in answer of the switch from paper to digital, I think it's important to note that both the Access Copyright license and the Copyback license covers the reproduction both in paper and digital. So the fact that instead of producing paper course packs, they now just PDF it and upload it on learning management system doesn't change the impact of consumption of works that are protected protected by copyright and not paid for. And the mechanism to pay for it is in the collective license to make it simple and easy for professors across the country to make the reproductions that they need to instruct their students, and ensuring at the same time the payment flows back to the creators.
Thank you. Thank you. We're going to move to Mr. Lloyd. You have, very quick 5 minutes.
Thank you for coming today, and I appreciated your testimony. I'm just going to reference the document here that was provided by the consortium, the CMEC Copyright Consortium, in which they talk about book sales in Canada, book sales in Ontario, Canadian publishing industry profit margin, and Canadian publisher sales of their own titles to K-12 institutions. And I was just looking maybe for some clarity from you. You guys don't actually sell books. You are a reproduction company. You and primarily derive your income from educational institutions. So do you think that these statistics really have any value for us as a committee?
Those statistics don't refer to the reuse rights, so the reproduction. That's for sales. And unfortunately, I'm not in a position to comment about the source of that data and how it marries with our own experience.
Let's assume, because it is Stats Canada data, that it is probably very accurate. But would you say that it's not really pertinent for this committee to review book sales when we're talking about copyright? Like, are they two totally different issues?
One thing to keep in mind is that what gets sold and what gets copied are sometimes different works. So a group of works that is not being bought can be copied. And so you may see sales revenues go up for this group of creators, but it's another group of creators that get reproduced and not paid for. And the example that we heard here over and over again is university libraries spending hundreds of millions and more than ever on science, technical, medical journals and not paying the reuse rights for the copying of chapters and short stories and plays that they upload on their learning management systems and share with their students. Two different groups of rights holders. One is primary sale, one is secondary revenues. One they pay for, one they don't pay for. The impact is not felt the same.
So
The
when
fact
we're-
that they pay for one
Yes.
does not give them a free pass to copying the other group of
So when we're
works.
looking at book sales, like you can't, like it's been put in previous testimony, you can't compare the average author to a J.K. Rowling, for example, who's selling millions of books around the world. Like these book sales are reflecting all books from all authors, including bestsellers. But when you actually look at the percentage that are educational books, it's probably a very small margin as a part of the overall book sales market in Canada.
Again, I don't know the source of that data, so I can't really comment about that data per se, but
I'll move
generally
along to another area,
speaking, I think your comments are accurate.
Okay, so, some witnesses have claimed that it's because of the increased use of digital content in our age of the internet that has led to a decreasing relevance for access copyright as a collective society, and by extension, copyback. Would you say that this is true, that is access copyright not really involved in the digital era?
So absolutely not. That is not correct. And I think what you need to do is look at the York University case. It is the time, the opportunity we had to actually see the content that gets used in course packs and on learning management systems at York University. In the context of that litigation, a study was done. Individual titles were looked at. The titles had to be determined whether they were in Access Copyright's repertoire, whether York had licenses, whether they were available under open access. And the outcome was that 360 pages per student per year were in Access Copyright's repertoire, were not being paid for, were not available under open access. That's an average of 360 pages per student per year. That is a huge amount of copying.
So, I guess my final question would be, in my conversation with the previous witnesses who came in today, they were talking about competing evidence coming in before the Copyright Board, and I was referencing the PwC's report, which was commissioned by Access Copyright, and then you had spoken about Copyright Board's decision, but they referenced and they said it was probably from Deloitte, that there was another piece of evidence in there. Can you elaborate on the differences, the contrast between those reports?
I think one thing that's important to note that got very confused in the earlier panel is which courts or tribunals have looked at the copying guidelines. The Copyright Board did not look at the copying guidelines, has not said anything about the fairness of the copying guidelines. Only the federal court in the York decision has had to examine the copying guidelines at 10%, the chapter, and determine whether it's fair. And it's in that context that there were dueling experts. In fact, there were two on each side. And the court concluded unequivocally that the fair dealing guidelines are arbitrary, they are unfair, and they lead to economic harm.
Thank you. Mr. Jahari, you have a quick 4 minutes.
Thank you, Mr. Chair.
Very quick 4 minutes.
Thank you, Ms. Levy and Ms. Cote. You were very clear, and thank you. You were very clear in explaining to us the difference between acquisition and between the reproduction. We're always trying to find what was the reason that the cost of acquisition was increasing, and now it's become at least clear for me that a lot of that it has to do with the articles as well as the publication that's being done and the transition into the digital. One of the other things we heard was that the students get their material for the instruction material either from Texas, from the textbook store, or they get it through the course packs. And usually the university or the libraries also buy 1 or 2 copies and just put it in the library. So We're also told that the number of course packs that are being created is also drastically reduced. And one example, when we were, I think we were in Halifax and we were looking at the university, and they said they have one course pack for all their curriculum. And we were saying, well, how could that be? So where are they getting the material? So if help me understand, if the textbooks are not showing up on the on the textbook store to buy, and the course packs are not created and printed, and I know you touched on it being digital now, and it's not part of the acquisition. Where are the students getting the material that they need to get instructor, and how does 600 million pages showed up?
So educational institutions across the country have what is called learning management systems, or essentially digital platforms that allow professors and students to upload content and share it with the class. And so they've gone from taking the material that was published and produced in course pack form to making it available on learning management systems. So it's not that they're not using the content anymore because it's not in a paper course pack. They're still using the content. They've now moved it from paper to digital, and it's still being used. And this we saw in the York University case, where we, because it was part of the discovery process of the case, we had a look not only on the paper course packs that they produce, but on everything that the university posts on learning management systems.
So do the university actually scan the textbook and they put the content in a PDF?
Sometimes they scan it, sometimes they already have it in the PDF, sometimes they extract it from a larger PDF. There are many ways that they get it in digital form and then upload it on learning management systems. Okay. The study, to be clear, the study that we did at York did not have anything to do with links. So any links that was excluded. It was just documents that were posted on learning management system. And importantly, in that study, we needed to see whether or not they already have the rights for those works, because you've heard hundreds of millions of pages, hundreds of millions of dollars being spent on accessing content. And those claims were made to the judge as well. So York said at the beginning of the process that most of what they copy, they have licenses for. By the end of the hearing, they had to abandon that claim completely, because they could not marry the works that they upload on learning management systems and copy in course packs with the licenses that they have. And it's not a question of faulty paperwork. It's because these are different works.
Okay, thank you.
Thank you. And for the final 2 minutes, Mr. Massey.
Mr. Chair, and so as this has progressed and we're going to hear hearings, and then we'll make a report to the minister, and then the minister will then respond to the report. And then I can imagine that it would take probably, if there's going to be some changes, legislation, which would be another review. Are there things in the interim that you would suggest that could be done from your perspective right now?
I think there are things that can be done immediately by communicating from the government's perspective whether they believe that this approach is right or not. Just signaling to the education sector is a start. The government has also committed to making some changes to the Copyright Board process. And while that does not touch on fair dealing, at least what is left after the ravages of fair dealing, at least what's left after all of that has been taken off, is something that is enforceable and usable. That would be another suggestion.
Has your organization conveyed that to the minister at this time?
Yes, we have.
Would you be willing to share that information to the committee?
Absolutely.
Okay, thank you.
To the clerk, that would be great. Anything else? We're good? Well, on that note, I think we could have spent 2 hours with you guys. I want to thank you both for coming in today and sharing your experience and your knowledge with the committee. And on that note, we will adjourn. Thank you.